he was wrong doesn't mean we can't factor that into his suspicion of drunk driving based on erratic driving within the lane. And that was one thing he was concerned about, whether it's a traffic infraction or not, is that it was an extremely early hour of the morning. This person was weaving within their own lane for no apparent reason, and they were also speeding. Officer Hopkins testified that he'd been a police officer for about 3 years, and he had received training in speed detection, not only through the use of a radar, but also through visual estimation. And over the course of 3 years, he's worked and he's made arrests, and he's familiar with speeding. There's a line of cases, the Guy case, the Starkweather case, the Steele case, the Paraboom case, that say you don't have to have a scientific source of measurement. In this case, Officer Hopkins would have liked to use a radar, but his car wasn't equipped with one. And by the time he did turn around and got behind the driver and could have utilized the pacing technique, this driver slowed down, which that's not unusual for someone to slow down as soon as they see an officer in the area. But he estimated it was 45 in a 30-mile-per-hour zone. Mr. Gillette cross-examined him a couple of times and even suggested to him, "You're just guessing, aren't you?" and goaded him into saying, "Yeah, it's a guess." But Officer Hopkins wouldn't do that, and he felt very confident in his estimate based on his training and experience that this driver was operating over the speed limit.
But, counsel, what about Mr. Gillette's point that this was all a pretext? The police officer knew from the officers doing surveillance on a believed known drug house that Mr. Butts was leaving from that area. They obviously didn't have probable cause to believe necessarily that he had any drugs on him, so they looked for a pretext, a reason to stop the car, figuring that although they had a suspicion, they could never prove it in court without having a reasonable belief that there was a crime being committed, in this case a traffic offense. So should we be concerned that this is a ploy or a pretext by law enforcement to stop the vehicle so they can get inside it and look for drugs?
I don't think that should be a concern of this court at all, because first of all, there were some officers that saw him leaving a known drug house earlier in the evening. Those officers didn't stop him. If the officers had been wanting to stop someone on a pretext, it should have happened then. But second of all, Officer Hopkins testified a couple of times, and there's nothing on the record to controvert this, that he did not know that Mr. Butts was seen at that drug house until after the stop had started and other officers had arrived and informed him of that. He did not know that.
Okay, let me give you a hypothetical. Let's change the facts a little bit. I want you to assume that Officer Hopkins knew at the time he saw the car traveling that he'd been at a drug house, that Mr. Butts was a known user of drugs and was known to carry drugs in his car at the time that he saw the speeding violation. Would that have made a difference?
It would not have made a difference provided that he saw the speeding violation, and that's from the Wren case, which is a United States Supreme Court case, which says a pretextual stop can be okay provided that the officer has a valid reason. Even if in the back of their mind they're thinking this is a known drug user, as long as they can find a valid legal reason to justify the stop, which in this case would be the speeding, then that stop is constitutionally permissible. But in this case, I don't believe, and I don't believe the record would bear out that Officer Hopkins knew any of this prior to making the stop himself. Basically, our reasonable suspicion inquiry, which is what he had to have to stop Mr. Butts, has to have two things. The first is that it had to be justified at the time he stopped him. And we have his observation of the speeding. We have his observation of the improper driving on a lane roadway, which turned out that it wasn't a traffic infraction, but it was still of interest to him. And then his concern about the early hour of the morning, and coupled with the erratic driving, that he suspected that this might be an intoxicated driver. So we have that part satisfied. The second part of the inquiry is whether the stop itself was related in duration and in scope to the initial reason for the speeding stop. And what the record shows is that Officer Hopkins immediately approached the driver and observed some additional indicators of intoxication, including odor of alcohol on his breath, bloodshot eyes, He also observed the passenger didn't have a seatbelt, and the stop went on from there. But basically, it proceeded relatively quickly to the point that within 2 hours, Mr. Butts was at the county jail and taking his breath test. And so we know it wasn't a particularly long stop. And Mr. Butts makes no argument that it was outside of the scope, I don't think, of the initial stop, although he does suggest that this entire stop was a fabrication by police officers. And I do think that's a problem in this case, because it does call this court to judge credibility of Officer Hopkins. And obviously Judge Boating was in a position where he saw him testify, reviewed the videotape of the stop a number of times, and found that Officer Hopkins was credible and that there was reasonable suspicion present in order for him to make the stop.
Most of the cases that are reported concerning this issue are not difficult to understand, are they? An officer opines that the driver was going 100 miles an hour, or there was the squealing of tires and difficulty stopping at an intersection. In this case, we're talking about an opinion that the defendant was going 40 miles an hour in a 25-mile-an-hour zone. Is that correct?
I believe it was 45 and a 30.
45 and a 30, so it's 15 miles. And so somewhere along the continuum, would you agree with me, it becomes a question of law. Suppose the officer was of the opinion that the defendant was going 31 miles per hour in a 30-mile-per-hour zone. Does that make it a more troublesome case? From a point of law, from a question of law issue, not a question of fact.
I don't think it does. Maybe we would disagree on that point, but I think even if you're going 1 mile over the speed limit, speeding is illegal. I mean, I guess...
Here we had no aid, such as the speedometer in the patrol car. We had nothing really to assist the officer in his observation of speed as the car is going in an opposite direction, other than his just eyeballing the car coming toward him. Is that correct?
That's correct, Your Honor.
Okay, thank you.
And his training and experience as an officer, which he probably, I mean, probably most of us could, I know Mr. Gillette doesn't think he could, but I think most of us could probably guess reasonably at speed, any of us who drive on a regular basis. But this officer had additional training and testing, because not only does he get to eyeball the speed, typically he'd have a radar and be able to check his visual estimation with a scientific measurement.
So I want to make sure I understand. Under the law, the check and balance in our system, in our judicial system, is for a trial judge to determine the credibility of the witness that has given the opinion. And there is no question of law. Is that your position?
My position is that the judge has decided on the officer's credibility as far as the speeding goes. You do have to decide whether, as a matter of law, all of these factors together can establish probable cause. So I think both analysis come into place.
I don't understand that probable cause argument. It seems to me that although you talk about swerving within a lane, you talk about being late at night, but it's on a public street in a city. What it comes down to is whether that officer had reasonable suspicion that the defendant was speeding, does it not?
That is what it comes down to. Reasonable suspicion that a crime was being committed or about to be committed. And in this case, he did focus on the speeding, although he articulated reasons to suspect it could also be intoxicated driver.
But Judge Boating didn't make any findings on that. Judge Boating's finding was specific, that he believed that the officer had a reasonable belief that Mr. Butts was speeding, period. He didn't address the DUI or the moving around inside the lane, correct?
I believed he just found that he had reasonable suspicion and that he acknowledged that he did think he was speeding specifically, but at any rate. I'd like to talk a little bit about the speedy trial issue as well. What we had here is that Mr. Butts we had 180 days to bring him to trial by statute, and he was brought to trial within 183 days. So what we're talking about is just a 3-day lapse over the statute. And just to be clear for the court, we're not arguing that all furlough days should count per se against the defendant in any given case. We're not arguing that this defendant acquiesced in any way, shape, or form to the delay, and we're not arguing that all of Judge Boating's time that he took, the motion under advisement, should be assessed against the defendant. Our sole argument is that under the totality of the circumstances, a reasonable time should be assessed against the defendant. And the judge did, and I'm not shy to take, I think he took too long to decide the issue, and that's something that I said on the record to the judge. I think the judge agreed with that, but he did say for the record this to him wasn't the easiest of cases to decide. He considered it a close call, and he mentioned that he reviewed a 2-hour video several times in order to decide the case, and that's going to take some time. In fact, that's going to take us outside the day in question, which it appears to me that Mr. Butts doesn't want any time assessed to him for that decision. It appears to me, based on his arguments, that he expected the court to rule immediately that day and that no time should be assessed against him if the judge took longer than that.
Counsel, how much time do you believe would have been reasonable for the trial court judge to rule on this motion?
More than 3 days?
Yes, somewhere more than 3 days. But
lucky guess.
The court himself, who I think is in the best position to say how long he thought it should take, I think he mentioned a period between, what did he say, 14 to 21 days, I think is what he said. And that was his own assessment of how long it should have taken him. But under these circumstances, Your Honor, I think assessing at least 3 days against the defendant is very fair. We had, Mr. Butts had submitted an additional motion as late as April 19th, 2010. An additional memorandum of law regarding this motion as late as April 19th through 2010, which is well within the, it was deep into the time that the judge had this under advisement. And so that's an additional factor I think the court has to consider in this case, is that shortly before the court made its decision, they submitted additional issues of law. Now, the court did invite them to do that. The court invited both parties to do that. The state declined because we felt we had briefed all of the issues we could brief and provided all the testimony we could, but we did have the defendant, Mr. Butts, submitting that late in the game. And so that also...
When was that request made by the court?
I can't give you the exact date that the court made the request, but it was within the time period of February 1st, 2010 and April 30th. I mean, obviously it was before April 19th. But the defendant did do that, which would cause the court, I would think, some additional delay in deciding the motion by reviewing the new issues of law that they brought up. I think the heart of the speedy trial argument is whether or not you believe a reasonable time should be assessed if the defendant doesn't file it close to speedy trial time. Mr. Butts has argued that a reasonable time should only be assessed if he waits till close in time. And I don't believe that's the state of the law, and I rely on the Southard case for that. It's a 1997 Supreme Court case where they do make the distinction. They say, we don't agree that there's a distinction between actual delay caused by the motion and time elapsed by the filing itself. We understand that courts have crowded dockets, and there has to be some reasonable assessment to ease the tension between the filing of the motion itself and the crowded docket. And I do think a reasonable time should be assessed in this case, and 3 days certainly is reasonable considering the circumstances. If you think it's longer than that, a lot of cases have provided 2 weeks roughly, but 3 days certainly is reasonable under the circumstances. Without any questions, I would stand on my brief. Thank you.
Thank you, Ms. Taylor. Mr. Gillette.
Thank you, Your Honors. I'll be brief. I want to touch on a few things. First, as Judge Knudsen pointed out, Starkweather, Whitehurst Guy, we responded to all those particular issues in our reply brief. Those particular cases that the state relies upon as far as speed involves an individual traveling at 100+ miles an hour, burning his tires, squealing in front of the officer as he's taking off. Clearly, that's probable cause and reasonable suspicion to pull somebody over. What troubles the defendant in this case is that we believe it is a pretextual stop. The officers all have the same radio, they're all listening to the same thing, and there is discussion overheard, and I know the officer says that wasn't the basis why he did it, but they all have the same radio channel, and they're all talking about what Bison Narcotics is doing watching this particular house. And just miraculously, Officer Hopkins arrives on scene and sees Mr. Butts driving by the other way and determines that he's not doing 30 miles an hour or 35 or 40 miles an hour, but he says he was going 45 miles an hour. And he turned around and then began following him. And in cross-examination, I asked the officer, I said, was he speeding when you followed him? He says, no. In fact, when I was able to pace him, he was doing the appropriate speed. That's issue one. Issue number two, Judge Boating deserves the time to respond to our motion to suppress. He heard all the testimony. He watched the videotape. In fact, on February 1st, after all that was done, he says, I'm going to have a decision for you within 48 hours. Well, 48 hours came and went. Ms. Tatum and I showed up. The judge said, well, I'm going to need a little bit more time. And he put it off another week. And then we came back. He says, I'm going to need some more time. And it went on and on. And yes, in response to your question, Your Honor, Judge Boating should get the appropriate time he needs to respond. But, and I'm willing to give him 48 hours even. If you take the 48 hours off the 183, we still got 181 days though. Clearly, Mr. Butt's speedy trial time had run at that point in time. And finally, the state indicates to this panel that we had filed an additional brief. Well, we sure didn't want to. Judge Boating particularly asked us to respond and give him additional case law and arguments on it. We did what the court asked us to do. We didn't raise any new issues. We gave the court additional research that the court requested at the time. We didn't acquiesce in anything. We didn't ask for additional time. We did what the court ordered us to do. I would ask this court to look at this and determine that Mr. Butt's constitutional rights have been violated in two ways. Number one, that there was no reasonable suspicion or probable cause to stop him in the first instance. And second of all, if the court should determine that there was, that his speedy trial time had run anyway, and that the case should have been dismissed.
Thank you, Mr. Gillette.
Thank you.
The court will be in recess. We have another argument at 11 o'clock, but as soon as we go back and get out of our robes, we're going to come back out and talk to anyone who would like to stick around. So with that, we will be in recess. Please be seated. I would also like to welcome you all here for this special session of the Kansas Court of Appeals in celebration of the 224th birthday of the United States Constitution. As a graduate of Kansas City, Kansas Community College, it's a special honor and privilege for me to be here, and it's an honor to be here with two extraordinary judges from the Kansas Court of Appeals. On my right, Judge Michael Boozer, and on my left, Judge David Knudsen. And I forgot to introduce her earlier, but the young lady who called the court in order is my research attorney, Casey Klein. Just so you know, everyone out here, the attorneys will have 15 minutes per side to argue. The appellant is given the opportunity to reserve some of their time for rebuttal. With that, we will go ahead and call the case of State of Kansas versus Rosalyn D. Is it Bethia? Bethia. Would you please state your appearances for the record?
May it please the court, Joanna Labastida of the Kansas Appellate Defender's Office for the appellant, Ms. Rosalyn Bethia.
Could you spell your last name for me?
It's L-A-B-A-S-T-I-D-A. And as I was not the attorney on the brief, my bar number is 24186.
And would you like to reserve any time for rebuttal?
If I may, Your Honor, I'd like to request 3 minutes to rebuttal.
That's fine.
And unless the court would prefer otherwise, I would like to focus on the first issue presented in the brief. That first issue presented in the brief is that the district court violated Ms. Bethia's constitutional right to confront witnesses against her when it refused to allow her to cross-examine Ms. Williams regarding her drug use the day of the incident. This issue involves the constitutional right to confrontation, therefore the appropriate standard of review is de novo. As the Supreme Court of Kansas has stated in State v. Osby, for purposes of discrediting a witness, drug use evidence is admissible to the extent that it shows the witness was under the influence of drugs at the time of the occurrence, as to which the witness is testifying. It's also admissible to the extent that it shows the witness's mind, memory, or powers of observation were affected by the habit. As stated in the brief, it's Ms. Bethia's argument that she does not have to first show that Ms. Williams was, that Williams's ability to recall was affected by the drugs before being allowed to cross-examine her on the issue. The Supreme Court requests that the threshold requirement for admission of such evidence be that there's a showing that the witness was under the influence at the time of the occurrence.
Counsel, could you just briefly give us the factual scenario? We're familiar with it, but so that
yes, absolutely.
Can kind of be aware of what the circumstances were.
Rosalind Bethia was convicted of aggravated battery related to an incident where Diane Williams was in her yard, and Ms. Bethia came over and asked her for money. They went inside. She took the money. Later on, Ms. Williams testified that Ms. Bethia came back and knocked down her door and demanded more money and started beating her with various objects around the apartment. Ms. Bethia left, and she was picked up later on and charged with several different crimes, but was acquitted of most of them except for the aggravated battery. An aggravated battery, I believe, was the battery that it caused great bodily harm was how it was charged. There was a motion in limine before trial where the court directed the defense attorney to question Ms. Williams about her drug use, and if she said she was affected by her drug use, then he could go forward and ask her other questions, but if she claimed that she was not affected by that drug use, that he had to stop questioning her about that. I believe the defense's argument was, well, how does she know she was affected by it unless I ask her more questions?